Before we begin, a quick and important disclaimer. This video explores the legal, social, and historical evolution of divorce in the United States throughout the 20th century. The following content is provided strictly for educational and entertainment purposes and does not constitute legal advice. Family law is complex and varies significantly by jurisdiction. Therefore, this information should not be used as a substitute for the counsel of a licensed attorney. Viewers are strongly encouraged to conduct their own due diligence and consult with a professional regarding their specific legal or personal situations. In 1900, if a man in America wanted to end his marriage, he didn't just need a lawyer. He needed a villain. He had to prove in a public court of law, often in front of a jury of his peers, that his wife had committed a specific, grievous sin like adultery, physical desertion, or extreme cruelty. If he couldn't prove it, he was legally bound to that woman until death, regardless of how much they hated each other. Fast forward to the end of the century, and the entire landscape had inverted. By the 1990s, the no-fault revolution had made divorce as simple as signing a few papers, yet it simultaneously created a multi-billion-dollar legal industry that many men felt was systematically designed to strip them of their assets and their children. We are looking at a century that began with the shame of the deserting husband and ended with the crisis of the fatherless home. This isn't just a dry history lesson. It is the story of how the American man's identity was dismantled and rebuilt by the courtroom. Understanding this history is the only way to make sense of the modern family court system. If you have ever wondered why custody battles feel so inherently adversarial, or why alimony, now often called spousal support, still exists in an era of dual-income households, the answers are buried in the legislative shifts of the 1920s, the post-war domestic explosion of the 50s, and the radical legal upheavals of the 1970s. By diving into this deep history, we are solving the mystery of the default settings of the American legal system. You will gain a clear-eyed perspective on the potential outcomes of domestic litigation by studying the case studies of the men who came before you, navigating a system that was transitioning from moral judgment to economic distribution. To understand where we are, we have to go back to the year 1900. At the turn of the century, the United States operated under a fault-based system. This was a direct inheritance from English common law and ecclesiastical courts. Divorce was not viewed as a civil right or a personal choice. It was a rare remedy for a legal wrong. For a man in the early 1900s, the stakes were incredibly high because a divorce carried a heavy social stigma that could end a career or result in total social ostracization. The law required an innocent party and a guilty party. If both parties were found to be at fault, a concept known as recrimination, the court would actually refuse to grant the divorce, essentially sentencing two people who hated each other to remain married as a punishment for their mutual misconduct. During this era, men were legally and socially defined as the head and master of the household. This came with a specific set of burdens. Under the doctrine of coverture, a woman's legal identity was largely submerged into her husband's. While this gave men immense control, it also created a lifelong financial mandate. When a divorce did occur, usually on the grounds of the husband's adultery or abandonment, the court viewed alimony not as a temporary bridge to self-sufficiency, but as a perpetual penalty for the husband's breach of the marriage contract. Because women had limited access to the workforce, a man who wronged his wife was often ordered to maintain her standard of living indefinitely. This was the birth of the alimony jail phenomenon, where men who fell behind on payments were routinely incarcerated, a practice that persisted well into the mid-century. As we moved into the 1920s, the Roaring Twenties brought the first major crack in this rigid structure. The urban migration and the rise of the new woman meant that more couples were seeking ways out of unhappy unions. However, the laws hadn't changed. This led to a fascinating and often deceptive period of American history, the era of collusive divorce. Because the law required a fault, but many couples simply wanted to part ways amicably, they began to manufacture evidence. Men would hire professional correspondents, essentially actresses, to be photographed in a hotel room with them in a state of undress. These staged photos were then presented to the court as proof of adultery. The husband would intentionally play the role of the villain, sacrificing his reputation to secure his freedom. This created a legal culture based on theatricality and perjury, where the truth of a relationship mattered less than the ability to provide the court with a legally recognized sin. This tension between the law and reality hit a breaking point during the Great Depression. As the economy collapsed, the ability of men to fulfill their head and master roles vanished overnight. Divorce rates actually dipped during the 1930s, but not because marriages were happier. They dipped because people couldn't afford the legal fees or the cost of maintaining two households. This era highlighted the brutal intersection of finance and family law. A man who couldn't pay his spousal support in 1932 wasn't just a deadbeat in the eyes of the law. He was a failure in the eyes of a society that linked masculinity directly to the provision of resources. Then came World War II, a pivotal turning point that fundamentally shifted the demographics of American divorce. When millions of men returned from overseas in 1945 and 1946, they found a country and a domestic life that had changed. The quickie divorce became a cultural phenomenon. Soldiers who had married in haste before shipping out returned to find they were no longer compatible with their wives. This led to the rise of divorce colonies, most notably in Reno, Nevada. Nevada realized they could turn a profit by shortening their residency requirements. A man could travel to Reno, live in a dude ranch for 6 weeks, and obtain a no-questions-asked divorce that was legally recognized back home. This was the first time in U.S. history that the potential outcomes of a marriage were dictated by geography. It created a two-tiered system. Wealthy men could fly to Nevada for a clean break, while working-class men remained trapped in the fault systems of their home states. By the 1950s, the nuclear family ideal was at its zenith, but beneath the surface, the legal pressure was building. This was the decade of the tender years doctrine. In the early 1900s, fathers often retained custody because children were seen as economic assets for farm labor. But by the 1950s, the legal pendulum had swung completely in the other direction. The courts adopted the presumption that young children belonged with the mother, and the father's role was reduced to that of a visitor and a checkbook. This set the stage for the massive civil rights and feminist movements of the 60s and 70s, which would eventually lead to the single most significant legal shift in the history of the American male: the adoption of no-fault divorce, starting in California in 1969. In the next sections of this masterclass, we will deconstruct how that one legislative change in California triggered a domino effect across all 50 states, permanently altering the math of asset division and the psychology of fatherhood. We will analyze the data on how no-fault impacted men's suicide rates, domestic violence statistics, and the long-term wealth gap between divorced men and women. This is the history of how the contract of marriage became the discretion of the court. To understand the earthquake that was no-fault divorce, imagine you are a man named Robert living in 1968. You have been married for 15 years. You work a steady job at a manufacturing plant, and your wife manages the household. The marriage has grown cold. There is no intimacy, no shared vision, just a quiet, grinding resentment. Under the laws of 1968, if Robert wanted to leave, he couldn't simply cite irreconcilable differences. He would have to prove his wife was an alcoholic, unfaithful, or physically abusive. If he couldn't prove a legal fault, he was stuck. But more importantly, if his wife wanted to leave him, she faced the same barrier. This created a strategic stalemate that defined the first half of the century. Then comes 1969. Governor Ronald Reagan signs the Family Law Act in California, and the stalemate is vaporized. For the first time in American history, a spouse could end a marriage unilaterally without proving the other person did anything wrong. The legal logic shifted from marriage as a permanent contract to marriage as an at-will partnership. What Robert didn't realize, and what millions of American men would soon discover, was that while the exit door was now wide open, the financial and parental costs of walking through it were being rewritten by a system that was still using 19th century assumptions about gender roles. The immediate historical trend following the 1969 California legislation was a staggering spike in divorce filings. In the first 5 years, the rate of divorce in some jurisdictions jumped by over 50%. This wasn't necessarily because people were suddenly unhappier, it was because the legal dam had burst. However, this period introduced a phenomenon that sociologists now call the feminization of poverty, which paradoxically led to a massive backlash against men in the courtroom. Because women were entering the workforce in higher numbers, but still earned significantly less than men, judges began to view the male paycheck as a communal asset that needed to be divided with surgical precision to prevent the state from having to support the ex-wife. Let us look at a specific case study from the mid-1970s. Consider a man in New York, which was one of the last states to hold on to fault-based requirements. In this era, the potential outcomes for a man were dictated by his ability to navigate a negotiated fault. To get his wife to agree to a divorce, a man would often have to sign over the entirety of the marital home and a massive percentage of his future earnings. This was the era of the king of the hill asset division. If the man was the primary earner, the court's priority was ensuring the wife and children stayed in the middle-class bracket, even if it meant the man moved into a one-bedroom apartment and lived on 30% of his take-home pay. Step by step, the 1970s dismantled the concept of the father as the disciplinarian and provider and replaced it with the father as the economic engine. This shift was fueled by the best interests of the child standard. On paper, this sounded like a noble gender-neutral goal. In practice, however, it solidified the tender years doctrine under a new name. Judges, who were predominantly men at the time, ironically held the sexist belief that men were naturally incapable of primary caregiving. Consequently, in over 90% of contested cases during this decade, the mother was awarded sole physical custody. The man was granted every other weekend and a Wednesday night dinner, provided he stayed current on his payments. This period also saw the rise of the standard of living metric. This was a calculation used by courts to determine alimony and child support. The goal was to ensure the children and the ex-wife did not experience a drop in their lifestyle. This created a mathematical impossibility for many men. If a household is supported by one income of $80,000, and that household splits into two, the cost of living doubles. Since the court prioritized the primary home, the man was often left to absorb 100% of the economic shortfall. Data from this era shows that while women's standard of living often dropped initially after a divorce, men's available income, what they had left after fixed costs and support, often plummeted even further, leading to a decade of working poor fathers who were technically middle class on their tax returns but lived in poverty in reality. As we moved into the 1980s, the legal system became even more aggressive. This was the decade of the Your case and the rise of professional license valuation. Imagine a man who spent 7 years in medical school, while his wife worked to support the family. In the 1980s, courts began ruling that a man's degree or his professional license was a marital asset. This meant that even if he hadn't started his practice yet, the projected future earnings of that degree could be appraised like a piece of real estate, and he would have to buy out his wife's share of his own brain. This was a radical expansion of the state's power over an individual's future labor. It wasn't just about what you had earned. It was about what the state decided you were capable of earning. Furthermore, the 1980s introduced the federalization of child support enforcement. In 1984, the Child Support Enforcement Amendments required states to adopt child support guidelines and introduce mandatory wage withholding. For the first time, the government was directly reaching into a man's paycheck before he even saw it. While intended to catch deadbeat dads, the broad brush of the law often caught men who were struggling with job losses or medical emergencies. The system was designed for efficiency, not for nuance. If you lost your job, your support obligation didn't stop. It continued to accrue as arrears, which in many states could not be discharged even in bankruptcy. Think about the psychological toll this historical trend took. We see a rise in what historians call the disposability narrative. By the late 80s, the American man was often portrayed in media and law as an optional component of the family unit, essential for his financial contribution but secondary in his emotional and developmental role. This was the era where the visiting father became the national norm. Step by step, the legal system had created a structure where a man's parental rights were inextricably linked to his financial performance. If he couldn't pay, he often felt he couldn't stay in his children's lives, leading to a tragic cycle of father absence that would haunt the census data for the next 40 years. We have now reached the peak of the no-fault era's first wave. We have seen how the law moved from punishing sin to managing assets. But something started to change in the 1990s. Men began to organize. The Fathers' Rights movement started as a fringe group in the 80s, but became a legal powerhouse in the 90s. They began to challenge the best interests standard, arguing that it was being used as a cloak for institutional bias. But as men started to fight back for custody, the legal system responded with a new, even more high-stakes weapon: the domestic tort. In the next part, we are going to look at how the 1990s turned the divorce court into a battlefield of psychological warfare, where allegations became as powerful as evidence, and the silver bullet strategy was born. If you think the financial loss was the hardest part of 20th century divorce, wait until you see how the legal system began to handle the very concept of the truth. We are entering the era of the high-conflict divorce, where the goal was no longer just to leave but to win. As we crossed the threshold into the 1990s, the landscape of divorce transformed from a bureaucratic dissolution of assets into a high-stakes arena of psychological warfare. This era introduced what legal scholars and sociologists frequently refer to as the silver bullet strategy. To understand this, imagine a man named David in 1994. David is a mid-level manager, a father of two, and he is facing a divorce. Under the no-fault laws of the previous 2 decades, David assumes the process will be a straightforward division of the house and a standard visitation schedule. However, David's attorney explains a chilling historical trend that emerged during this decade: the use of tactical allegations to secure immediate, unilateral control of the family unit. The silver bullet refers to the practice of filing a restraining order based on an allegation of domestic violence or child abuse right at the onset of a divorce filing. In the 1990s, the legal system, responding to a genuine and necessary push to protect victims of abuse, implemented ex parte orders. These are temporary orders granted by a judge without the other party being present. For a man like David, this meant he could arrive home from work to find the locks changed, a police officer on his porch, and a legal document stating he could not come within 500 feet of his children or his home until a hearing 2 weeks later. In the 1990s, these 2 weeks were often the most critical period of the entire litigation. They established a new status quo. By the time David got his day in court to contest the allegations, the mother had already established herself as the sole caregiver in the eyes of the law, making it statistically much harder for David to regain a 50-50 custody arrangement. This decade also saw the professionalization of the high-conflict divorce industry. The 1990s gave rise to a specialized class of custody evaluators, guardians ad litem, and forensic psychologists. While these professionals were intended to provide objective data to the court, the potential outcomes for men often depended on their ability to fund a war of experts. If one side hired a psychologist to testify that the father was emotionally distant, the father had to hire his own expert to debunk that claim. This created an economic barrier to entry for justice. Data from the mid-90s suggests that a contested divorce involving custody disputes could easily cost a man upwards of $50,000 to $100,000 in legal and expert fees. Adjusted for inflation, that is nearly double in 2026 value. Many men simply ran out of money before they reached the finish line, forced to settle for minimal visitation because they could no longer afford to fight. Step by step, the 1990s also refined the concept of imputed income. This is a critical legal mechanism that every man studying this history needs to understand. Suppose a man had a high-paying job as an engineer but was laid off during the 1991 recession. He takes a lower-paying job to keep the lights on. In a 1990s courtroom, the judge could rule that because he had the capacity to earn the higher salary, his child support and alimony would be calculated based on the money he was not making. This was called imputing income. The court essentially treated the man's potential as a liquid asset. If he couldn't find a job that matched his previous peak earnings, he would fall into arrears. This created a massive historical trend of men entering a cycle of permanent debt to the state, as interest on unpaid support in many states was set at a staggering 10 to 12%. Let us look at a case study regarding the relocation laws of the late 90s. Consider a father in Illinois who had secured a hard-fought joint custody agreement. In 1996, his ex-wife decides to move to California for a new job or a new relationship. During this period, the legal standards for move-away cases were heavily weighted in favor of the primary custodial parent, which was still statistically the mother in the vast majority of cases. The court's logic was often that what was good for the mother's career or happiness was inherently good for the child, even if it meant the father's relationship with the child was effectively severed by 2,000 miles of distance. This era taught men that a joint custody paper was only as strong as the physical proximity of the parents. Thousands of men in the 90s went from being active, every other day parents to summer vacation dads, simply because the court prioritized the custodial parent's right to travel over the non-custodial parent's right to parent. The 1990s also introduced the parental alienation debate into the mainstream legal consciousness. While controversial, this period saw the first widespread recognition of how one parent could psychologically manipulate a child to reject the other parent. For the 20th century man, this was a new kind of battlefield. It wasn't about who had the most money or who was the guilty party in the marriage anymore. It was a battle for the child's mind. Men began to see how the win-at-all-costs culture of the 90s divorce could lead to a total erasure of the paternal bond. This led to the formation of some of the first organized advocacy groups that pushed for presumptive shared parenting, arguing that the default starting point of any divorce should be 50-50 custody. However, the resistance to 50-50 custody was immense. Powerful lobby groups, including certain bar associations and advocacy organizations, argued that a 50-50 presumption would put children at risk and strip judges of their discretion. This word, discretion, is the most important word in the history of 20th century divorce. It meant that despite what the written law said, the personal biases of a single judge could determine a man's financial and parental future. If a judge grew up in a traditional household where fathers were only providers, that judge was statistically less likely to grant a father primary custody, regardless of the father's actual involvement in the child's life. As we reached the end of the 1990s, a new financial instrument began to dominate the divorce conversation: the Qualified Domestic Relations Order, or QDRO. Before the late 20th century, a man's pension was often considered his own. But by the 1990s, retirement accounts became the primary target for asset division. A man who had worked 25 years at a company with the expectation of a stable retirement suddenly found that 50% of his future security was being transferred to an ex-spouse. When combined with the division of the marital home and the ongoing support payments, many men found themselves starting over at age 50 or 55 with zero net worth. The historical trend was clear. The 20th century ended with the total economic deconstruction of the divorced male. But the story doesn't end with financial ruin. As the clock ticked toward the year 2000, a new technological factor began to emerge that would change the evidence game forever: the digital trail. The early days of the internet, email, and cell phone records began to replace the private investigator of the 1940s. The 1990s set the stage for a world where every text, every late-night email, and every credit card swipe would be used as a weapon in the courtroom. We have analyzed the shift from moral fault to economic distribution, and finally to psychological warfare. But there is one final piece of the puzzle that many people overlook. It is the story of how the state itself became a third party in every American marriage. In the next part, we are going to look at the hidden financial incentives that states had to keep child support payments high, and how the Title IV defunding of the Social Security Act turned the collection of child support into a profitable enterprise for local governments. We are moving from the personal tragedy of the individual man to the systemic machinery of the divorce industrial complex. If you ever wondered why the system seems to resist change even when everyone agrees it's broken, you are about to see the money trail that explains it all. To understand why the family court system often feels like an immovable machine, we have to look at a piece of federal legislation that most people have never heard of: Title 4D of the Social Security Act. This is the moment where the divorce of an individual man ceased to be a private family matter and became a matter of federal fiscal policy. Imagine a man named Mark in 1998. Mark is a responsible father. He wants to be involved in his children's lives, and he is prepared to pay his fair share. What Mark does not realize is that he is stepping into a system where the state government has a direct financial incentive to ensure his child support payments are as high as possible. The historical trend began in 1975, but reached its aggressive peak in the late 90s. Under Title 4D, the federal government began providing incentive payments to states based on the amount of child support they collected. For every dollar a state agency collected from a non-custodial parent, the federal government would provide a percentage-based kickback to the state to help fund their enforcement programs. While the original intent was to recoup the costs of welfare payments made to single mothers, the law was eventually expanded to cover all child support cases, regardless of whether the family had ever received public assistance. This created a divorce industrial complex where the state acted as a collection agency with a commission. For Mark, this meant that when he went to court, he wasn't just negotiating with his ex-wife. He was negotiating against a system that viewed his future earnings as a source of federal subsidies for the state's general fund. Step by step, this led to the creation of rigid child support guidelines. Before this federal intervention, judges had vast discretion to look at a man's actual expenses: his rent, his car payment, his student loans. But to maximize federal funding, states needed a predictable, automated way to calculate support. They moved to income shares models or percentage of income models. These formulas often ignored the father's cost of living. If the formula said Mark owed 25% of his gross income, he owed 25%, even if that left him with insufficient funds to provide a bedroom for his children when they visited him. This created a paradoxical historical trend. The more a man worked to get ahead, the more the state collected in incentive payments, often leaving the man in a state of perpetual financial stagnation. Let us look at a case study from the mid-1990s involving the collection of arrears. In many states, once a child support order was entered, it became a judgment by operation of law. If Mark lost his job or suffered a medical emergency and missed 3 months of payments, those missed payments became a debt that no judge could retroactively reduce. In the 90s, the Bradley Amendment made it federally illegal for states to allow judges to forgive child support debt, even if the mother agreed to it or if it was proven that the father was not actually the biological parent. This created a debtor's prison dynamic without the bars. Mark could have his driver's license suspended, his professional licenses revoked, and his passport denied. By taking away his ability to drive to work or practice his trade, the system effectively ensured he would fall further behind, increasing the debt, on which the state could continue to claim administrative fees and interest. The scale of this machinery is massive. By the end of the 20th century, the amount of unpaid child support debt in the United States had ballooned into the tens of billions of dollars. However, a significant portion of that debt was not actually money owed to children. It was interest and penalties owed to the state. Case studies from this era show that low-income men were hit the hardest. A man earning minimum wage could be ordered to pay an amount that was mathematically impossible to sustain, while also paying for his own basic needs. When he inevitably failed, the state's enforcement mechanisms, funded by those Title IV federal dollars, kicked into high gear, further alienating the father from the family unit. Imagine if the legal system treated any other contract this way. If you buy a car and can't make the payments, they take the car, but they don't take your license and prevent you from ever buying another car. In the family court system of the late 20th century, the contract of fatherhood was treated as a one-way financial obligation where the state held all the leverage. This period also saw the rise of the private collection industry. Because there was so much money to be made in child support enforcement, private companies began contracting with states to track down fathers. These companies often used aggressive tactics, including public shaming on posters or early internet websites, which further damaged a man's ability to find employment and fulfill his obligations. Furthermore, we must examine the service of process scandals of the 1990s. In many high-conflict cases, men were never even properly notified that they were being sued for child support. This became known as sewer service, where a process server would claim to have delivered the papers but actually threw them in the sewer. The court would then enter a default judgment against the man. By the time the man found out, months or years later, he was already thousands of dollars in debt with no legal recourse to challenge the original amount. The historical trend shows that the system prioritized the speed of the order over the accuracy of the facts, because a fast order meant a faster flow of federal incentive dollars. This financial architecture explains why the movement for 50-50 custody faced such stiff institutional resistance. If a father has 50-50 custody, the child support amount is typically significantly lower or even zero. For the state, this means fewer dollars collected and consequently, lower federal incentive payments. The divorce industrial complex wasn't just a collection of lawyers and judges. It was a self-sustaining ecosystem of state agencies, software contractors, and federal auditors. A man in the 1990s was not just fighting his ex-spouse for time with his kids. He was fighting a multi-billion-dollar revenue stream that depended on him being a visitor, rather than a parent. This systemic pressure had a profound impact on the no-fault philosophy. While no-fault was sold as a way to reduce conflict, the financial incentives of Title IV actually increased conflict by making the custodial parent designation a valuable financial prize. If a mother secured custodial status, she secured a steady stream of income that was often tax-free and exempt from most debt collection. If a father lost that status, he lost his income, his assets, and his legal standing. The 20th century didn't end the war of divorce. It simply changed what the parties were fighting for and gave the state a seat at the table to collect the spoils. We have now pulled back the curtain on the financial engine of the family court. We have seen how the law, the money, and the power converged to create a system that many men found impossible to navigate. But there is another side to this history that is even more personal. It is the story of the identity crisis of the American male. As the legal system stripped away the traditional roles of husband and father, men were forced to redefine what it meant to be a man in a society that seemed to only value their utility as a paycheck. In the next part, we are going to dive into the psychology of the displaced father. We will look at the rise of support groups, the heartbreaking data on parental alienation syndrome, and how the 20th century man began to find his voice in a system that had tried to silence him. We are moving from the cold hard cash of the state to the raw emotional reality of the men who survived it. How did they rebuild? And what happens when a generation of children grows up watching their father struggle against the machine? The answers will redefine everything you think you know about the broken home. To understand the psychological fallout of the 20th century divorce machine, we must examine the collapse of the male identity that occurred when the law effectively deleted the role of the father as a domestic presence. Imagine a man named James in 1992. For a decade, James has defined himself by his participation in the daily rituals of his children's lives, making breakfast, coaching soccer, reading bedtime stories. Then, through a series of standard legal maneuvers we have already discussed, James is transformed into a visitor. He is now a man who sees his children for 4 days a month. This is not just a change in schedule. For James, it is a catastrophic loss of purpose. In the 1990s, this specific type of grief was often dismissed by the legal system as mere bitterness, but historical trends show it was actually the beginning of a profound mental health crisis for American men. Step by step, the removal of a man from his home environment triggers a physiological and psychological stress response that the 20th century legal system was never equipped to handle. When a man like James loses his home, his daily routine, and his primary social connection, his family, he enters a state of social isolation. Data from the late 20th century indicates that divorced men were significantly more likely to experience clinical depression and substance abuse issues compared to their married or never married counterparts. This wasn't because men were inherently weaker, but because their entire support system was often tied to the nuclear family unit that the court had just dismantled. The historical trend was clear. While the law focused on the division of bank accounts, it completely ignored the division of the human psyche. This leads us to the controversial but essential case study of parental alienation syndrome, a term coined by Richard Gardner in the 1980s that gained massive traction in the 1990s. Imagine if every time James tried to call his children, the phone was busy, or he was told they were sleeping. Imagine if, during his limited visitation, his children were cold, distant, or repeated phrases that sounded like they came from a legal deposition. James is experiencing what many men in the late 20th century called the slow erasure. This wasn't just about missing a weekend. It was about the systematic destruction of the child's affection for the father, often encouraged by a legal system that rewarded the primary parent for proving the other parent was unnecessary. The potential outcomes for men in these scenarios were often tragic. Because the 1990s legal system viewed mothers as the natural emotional core of the family, a father's claims of alienation were frequently met with skepticism. Judges often viewed a child's rejection of their father as the child's choice, failing to recognize the intense psychological pressure a child feels to align with the custodial parent for their own survival. This created a generation of lost fathers who eventually stopped fighting, not because they didn't love their children, but because the emotional cost of being rejected by their own flesh and blood, compounded by the financial drain of the court, became more than they could bear. Let us look at the rise of the support group movement as a counter-trend. By the mid-1990s, men began meeting in church basements and community centers to share their experiences. These weren't just griping sessions, they were survival meetings. These groups were the first to identify that the broken home was often a manufactured byproduct of the litigation process itself. They began to document the script of the high-conflict divorce, the false allegation, the move away, the child support hike, and the eventual alienation. For the first time, men like James realized they weren't alone in their failure. They were parts of a demographic trend that was being fueled by the Title IV incentives and the no-fault loopholes we discussed earlier. This era also saw a radical shift in how men viewed the institution of marriage itself. As the 20th century drew to a close, the marriage strike, or the MGTOW precursors, began to bubble in early internet forums. Men were looking at the case studies of their fathers and older brothers, men who had worked 30 years, played by the rules, and ended up in studio apartments with supervised visitation, and they were doing the math. The 1990s marked the first time we saw a significant delay in the age of first marriage for men. It wasn't just a cultural shift toward extended adolescence. It was a rational response to a legal system that many men perceived as having a 100% risk rate with no clear protection for the male contributor. Furthermore, we must examine the impact on the children, specifically the sons of these 20th century divorces. Step by step, a generation of boys grew up watching their fathers struggle against the state. This created what sociologists call the fatherless cycle. But with a 1990s twist, these boys didn't just grow up without fathers, they grew up with shadow fathers, men who were physically present in the same city, but legally barred from being parents. The data on the potential outcomes for these children is startling. Higher rates of incarceration, lower educational attainment, and a profound distrust of the legal and marital systems. The 20th century divorce machine wasn't just processing men. It was preconditioning the next generation of men to view the state as an adversary in their personal lives. Now imagine if the system had focused on parallel parenting instead of winning. In the late 90s, a few visionary jurisdictions began to experiment with mandatory parenting classes and mediation. They tried to move away from the plaintiff versus defendant terminology. However, these efforts were often sabotaged by the inherent adversarial nature of the legal profession. A lawyer's job is to win for their client, and in a divorce, winning usually means taking something away from the other person. For a man in 1999, the legal system was a zero-sum game. If his ex-wife won more time or more money, he by definition lost his connection to his heritage and his future. As we reached the turn of the millennium, the tension was at a breaking point. The financial machinery was humming, the psychological toll was mounting, and the first generation of no-fault children were reaching adulthood. Men were no longer willing to be the silent providers who went quietly into the night. They were starting to use the very tools of the system, the data, the constitutional challenges, and the organized lobbying to demand a seat at the table. The 20th century ended not with a resolution, but with a declaration of war on the status quo. But what happens when the battle moves from the courtroom to the legislature? What happens when men realize that the laws themselves are the problem, not just the individual judges? In the next part, we are going to look at the legislative revolution of the early 2000s and the fierce counterattacks that followed. We will explore the secret history of how 50-50 custody bills are killed in committee and who benefits from keeping the visitor status in place. We are moving from the individual struggle of James to the high-level political theater that decides the fate of every American father today. The 20th century was the build-up. The 21st century is the explosion. If you thought the silver bullet was the peak of the conflict, wait until you see how the battle for the presumption of equality is being fought in the state capitals right now. The battle for the presumption of equality did not begin in a courtroom. It began in the smoky committee rooms of state legislatures where the definition of fatherhood was being quietly bartered for political capital. To understand this transition, imagine a man named Michael in the year 2000. Michael has just emerged from a grueling 3-year divorce where he was granted the standard 1990s visitor package, every other weekend and 4 hours on a Wednesday night. Michael realizes that his judge wasn't necessarily a bad person. The judge was simply following a set of antiquated statutes that didn't recognize a father's fundamental right to parent. Michael joins a growing historical trend of men who stopped hiring divorce attorneys and started hiring lobbyists. This is the moment when the personal grievance of the American man became a legislative movement known as shared parenting. Step by step, these early 2000s advocates began to challenge the very core of the best interests of the child standard. They argued that the standard was too vague, allowing judges to inject personal biases into their rulings. In states like Florida, Michigan, and Kentucky, these groups began introducing bills that would create a legal presumption that 50-50 shared parenting is in the best interest of the child, unless one parent is proven unfit. For a man like Michael, this would mean he starts the legal process on equal footing with his ex-wife, rather than starting at a disadvantage and having to climb a mountain of legal fees just to reach a baseline of involvement. However, as these bills gained traction, they hit a wall of institutional resistance that few expected. The first major obstacle in the legislative revolution was the Bar Association. In several high-profile case studies from the early 2000s, state bar associations, the very organizations that represent divorce attorneys, emerged as the most vocal opponents of shared parenting legislation. From an economic perspective, the logic was simple: 50-50 custody reduces conflict because there is less to fight over. If the law presumes equality, the incentive for a high-stakes, $100,000 custody battle vanishes. For the multi-billion-dollar divorce industry, shared parenting was an existential threat to their billing hours. Historical trends show that whenever a 50-50 bill was introduced, it was often met with intense lobbying from legal professionals who claimed that such a presumption would put children in harm's way or clog the courts with litigation. Let us look at a specific case study from North Dakota in 2014, which serves as a perfect microcosm of this 20th century hangover. A ballot initiative was proposed that would have made 50-50 custody the default. Despite massive support from the public and father's rights groups, The initiative was defeated after an expensive opposition campaign funded largely by the legal and domestic violence advocacy communities. The opposition argued that a one-size-fits-all approach was dangerous, but for the men watching from the sidelines, it felt like a coordinated effort to protect the financial interests of the divorce industrial complex. This sparked a new realization. The system wasn't just broken. It was protected by those who profited from the breakage. During this same period, we have to examine the role of the gender gap in alimony. While the 20th century began with alimony as a tool to protect stay-at-home mothers, the 2000s saw the rise of the lifetime alimony controversy. Imagine a man who was married for 20 years and is ordered to pay a third of his income to his ex-wife for the rest of his life, even if she is cohabitating with a new partner or if he wants to retire. In states like New Jersey and Massachusetts, men began to organize specifically around alimony reform. They argued that in an era of dual-income households, the idea of permanent spousal support was a relic of the 1920s that treated women as incapable and men as indentured servants. The historical trend here was a shift toward durational alimony, where support is tied to the length of the marriage and intended only as a transitional bridge. However, even with these small victories, the potential outcomes for men remained highly unpredictable. This led to the rise of what we now call gray divorce. In the latter part of the 20th century and into the early 21st, divorce rates for couples over the age of 50 doubled. For these men, the stakes were no longer about custody. They were about the total liquidation of a lifetime of savings. Step by step, the courts began to apply the same aggressive asset division to 401ks and pensions that they had once applied to the family farm. A man at 60 years old found himself losing half his retirement and being ordered to pay alimony based on a peak career salary he could no longer sustain as he approached retirement age. This created a generation of men who literally could not afford to stop working. To illustrate the psychological impact of this legislative stalemate, imagine a scenario in 2026. A young man enters his first marriage with the knowledge of everything we have discussed. He has seen the Title 4D incentives, he knows about the silver bullet strategy, and he understands the risk of alimony. This awareness has led to the prenuptial revolution. Once reserved for the ultra-wealthy, prenuptial agreements became a standard tool for middle-class men in the early 21st century to opt out of the default state laws. They were essentially creating their own private family law to bypass a public system they no longer trusted. But even then, the courts often found ways to set these agreements aside if they were deemed unconscionable, showing that the state is very reluctant to give up its power over the domestic contract. The data from this era suggests that the legislative battle is far from over. While over a dozen states have now passed some form of shared parenting guidance, the presumption of equality remains the exception rather than the rule. The historical trend shows that for every step forward in fathers' rights, there is a corresponding pushback from the revenue-generating side of the machine. The divorce industrial complex has proven to be incredibly resilient, adapting its language to sound child-centered, while maintaining the same adversarial structures that ensure high legal fees and high state collection incentives. As we look at the legacy of the 20th century, we see a trail of displaced fathers, liquidated assets, and a fundamental shift in the social contract between men and the state. The American man went from being the legally protected head and master to a disposable participant in a system that views him primarily as a financial resource. This evolution has changed how men approach relationships, how they view their careers, and how they raise their sons. The 20th century was the century where the family court was built. The 21st century is the century where its foundations are being interrogated by a generation of men who have nothing left to lose. But there is a darker side to this legislative war that we haven't touched on yet. While men were fighting in the state capitals for 50-50 custody, a new form of social engineering was being developed in the background. It involves the use of administrative law to bypass the constitutional protections of the courtroom altogether. In the next part, we are going to dive into the star chamber of child support agencies. We will explore how these agencies can seize bank accounts, suspend licenses, and report to credit bureaus without ever having to prove their case before a jury. We are moving from the legislative debate to the world of automated enforcement. If you thought the discretion of a judge was scary, wait until you see the certainty of an algorithm. We are entering the era of the digital debtor, where your identity is your debt. The transition from the judge's chambers to the administrative office marked the final industrialization of the American divorce process. To understand how this functions, imagine a man named Thomas in 2005. Thomas is a construction contractor. He isn't a criminal, and he has never set foot in a jail cell. However, due to a clerical error in the state's automated child support system, he is flagged as being $2,500 behind on his payments. In the 1950s, Thomas would have had a day in court to explain the discrepancy. In the era of automated enforcement, the machine doesn't need to hear from Thomas. Without a single human being reviewing his file, the system triggers a series of administrative actions. His bank account is frozen, his professional contractor's license is flagged for non-renewal, and a negative report is automatically transmitted to all 3 major credit bureaus. This is the star chamber of the 21st century, a place where the burden of proof has been completely inverted. Step by step, the implementation of the State Disbursement Units or SDUs during the late 90s and early 2000s removed the human element from family law. These units are essentially massive data processing hubs. When a man's employer withholds child support from his paycheck, that money goes to the SDU, which then processes it and sends it to the custodial parent. While this sounds efficient, the potential outcomes for men like Thomas are often catastrophic when the data is wrong. Because these agencies operate under administrative law rather than criminal or civil court law, they have the power to seize assets without a prior hearing. This is a concept known as a pre-deprivation seizure. For Thomas, this meant that by the time he could even get a human being on the phone to show his receipts, his business was already failing because he couldn't pay his crew or buy materials with a frozen account. The historical trend here is the shift from judicial oversight to bureaucratic automation. In the mid-20th century, the court was a place of record where facts were debated. By the end of the century, the Child Support Agency had become a quasi-judicial body with more power over a man's daily life than the local police department. Data from this period shows that administrative errors in these systems were not rare. They were a systemic feature of a rapidly digitized bureaucracy. For a man, the identity of the debtor became his primary legal status. The state no longer viewed him as a father who was struggling. It viewed him as a non-compliant data point in a federal reporting system. Let us look at a case study involving the suspension of driver's licenses. In the late 20th century, states began passing laws that allowed child support agencies to suspend the driver's licenses of men who were behind on payments. The logic was that the threat of losing the ability to drive would compel men to pay. However, for many working-class men, this created a feedback loop of failure. If a man cannot drive, he cannot get to his job. If he cannot get to his job, he cannot earn money. If he cannot earn money, he falls further behind. This historical trend highlights the disconnect between the enforcement mechanism and the practical reality of male employment. In many states, once a license is suspended administratively, the requirements to get it back are so stringent, often requiring the payment of the entire balance in full, that a man is effectively barred from the legal economy for years. Imagine if you were told that you had to pay a debt, but the interest on that debt was higher than the rate of inflation, and the entity you owed the money to was the same entity that had the power to put you in jail for not paying it. This was the reality for millions of men as we moved into the 2000s. The interest rates on child support arrears in states like California or New York remained at 9 or 10%, even when the national interest rate was significantly lower. This meant that for a man who hit a rough patch, his debt could double in less than a decade, creating a lifelong financial obligation that could never be settled. Step by step, the state had created a system where a man's past became a permanent anchor on his future. Furthermore, we must examine the intersection of these administrative powers with the rise of the digital credit economy. In the 20th century, a man's reputation was local. In the 21st century, a man's reputation is a number. By allowing child support agencies to report directly to credit bureaus, the state gained the power to destroy a man's ability to rent an apartment, buy a car, or even get certain types of insurance. For a divorced man, this meant that the fallout of his marriage followed him into every aspect of his survival. Even if he was a dedicated father, a single administrative hiccup in the state's computer system could render him a financial pariah. The potential outcomes of this automation extended to the very concept of the right to travel. By the end of the 20th century, federal law mandated that anyone owing more than $2,500 in child support be denied a U.S. passport. For men with families abroad or those whose jobs required international travel, this was a total restriction of movement. This wasn't just about debt collection. It was about the state asserting total control over the individual. It created a class of citizens who were effectively trapped within state lines, unable to seek better opportunities elsewhere until their debt to the machine was cleared. This era also saw the rise of private-public partnerships in enforcement. Many states began outsourcing the management of their child support databases to private technology companies. These companies were often paid based on the volume of cases they processed, creating an incentive for quantity over quality. This led to thousands of cases where the wrong man was targeted due to name similarities or incorrect Social Security data. For the individual man, fighting a private corporation that is contracted by the state is a legal nightmare. The corporation points to the state, and the state points to the corporation, while the man's bank account remains empty. Step by step, the 20th century ended with the total surveillance of the divorced man. Every paycheck, every tax return, and every new job was tracked through the state directory of new hires. This was a massive database designed to ensure that no man could escape his obligations. While framed as a tool for children's welfare, it effectively turned every employer into a state informant. This changed the relationship between men and the workforce. Some men chose to work under the table, or in the shadow economy specifically to avoid a system they felt was unfairly weighted against their survival. This created a lost generation of tax revenue, and a lost generation of men who felt they could never truly participate in the formal American dream again. We have seen how the courtroom became an office, and how the judge became an algorithm. The 20th century history of divorce for men is a history of increasing efficiency at the cost of individual nuance. But there is one final piece of the story that we must address. It is the story of the rebellion of the sons. As the children of the 1980s and 90s divorce boom came of age, they began to look back at what happened to their fathers with a critical eye. They are the ones now entering the workforce, the voting booths, and the marriage market. In the next part, we are going to look at the generational shift. We will examine how the experience of watching their fathers lose everything has changed the way young men in 2026 approach the concept of family, law, and the state. We are moving from the history of the law to the future of the culture. Is the traditional family unit as we know it becoming a high-risk asset? And what happens when a society stops being able to offer men a stable path to fatherhood? The answers are already showing up in the birth rates and the housing market. We are about to see the long-term consequences of a century of litigation. To understand the long-term consequences of this century of litigation, we must look at the generational transfer of trauma and the resulting shift in how the modern American man calculates risk. Imagine a young man named Ethan in the year 2026. Ethan was born in 1996. He grew up in a household where his father was a shadow figure, a man he saw on alternating weekends, whose primary interaction with the family was a monthly transfer of funds overseen by a state agency. Ethan watched his father live in a small, sparse apartment while his mother remained in the family home. He heard the arguments about arrears, saw the stress of the driver's license suspension, and witnessed the eventual emotional withdrawal of a man who felt he had been replaced by a court order. Today, as Ethan enters his 30s, his approach to the traditional milestones of adulthood, marriage, homeownership, and fatherhood is fundamentally different from his grandfather's in 1950. The historical trend we are witnessing in 2026 is what sociologists call the risk aversion epoch. For a man like Ethan, the potential outcomes of a legal marriage are no longer viewed through the lens of romantic aspiration, but through the lens of asset protection and personal liberty. Data from the early 2020s shows that the marriage rate in the United States has reached its lowest point since record-keeping began in the late 1800s. This is not merely a change in social preference. It is a direct response to the 20th century history of divorce we have been deconstructing. Men have become students of their fathers' failures. They have seen that the legal contract of marriage, as currently constructed, offers them very little in the way of protection while exposing 100% of their future labor and assets to judicial and administrative discretion. Step by step, this has led to the rise of the domestic partnership and cohabitation models as a survival strategy. In 2026, many men are opting for long-term relationships without the state's involvement in their union. They are intentionally avoiding the marriage license because they view it as a Trojan horse for the divorce industrial complex. However, the legal system is already adapting to this shift. In several states, we are seeing the expansion of common law principles or palimony statutes designed to capture the assets of unmarried men who have cohabitated for a specific period. This indicates that the state is unwilling to lose the revenue streams generated by domestic litigation, even as men try to opt out of the formal system. Let us look at a case study regarding the housing market and the wealth gap. In the 20th century, the family home was the primary vehicle for middle-class wealth. Divorce typically required the sale of that home or the buyout of one spouse's interest. For many men, this meant the total liquidation of their primary asset at a time when they were also facing increased support obligations. This historical trend has created a generation of renter fathers. In 2026, we see a significant segment of the male population over the age of 45 who have zero home equity because their wealth was redistributed during a midlife divorce. This has long-term implications for the U.S. economy, as these men enter retirement without the safety net of a paid-off mortgage, placing further strain on social services. The psychological impact on the sons of divorce has also manifested in what is known as the birth rate crisis. When men perceive that their access to their children is conditional upon the whim of a judge or the financial satisfaction of an ex-spouse, their incentive to become fathers diminishes. Case studies from 2026 show that young men are increasingly seeking permanent sterilization or simply choosing to remain childless. They cite the custody risk as a primary factor. If the potential outcomes of fatherhood include a 90% chance of being reduced to a visitor with a 20-year debt obligation, the rational choice for many is to avoid the risk altogether. This shift is not just personal. It is a demographic earthquake that is threatening the future labor force and the stability of the social security system. Furthermore, we must examine the impact of the digital man in 2026. Unlike the fathers of the 1970s, modern men have access to vast amounts of data and community support via the internet. They are using apps to track every penny of support, using body cameras during custody exchanges to protect against false allegations, and using AI-driven legal tools to research case law. This is the era of the high-information father. Step by step, men are leveling the playing field not by changing the laws, which we have seen as a slow and difficult process, but by using technology to create an indisputable record of their involvement and compliance. This has led to a fascinating counter-trend: the litigation-proof lifestyle. Men are intentionally keeping their overhead low, avoiding large debt, and diversifying their assets into forms that are harder for the SDU algorithms to seize. Imagine a scenario where the state's aggressive enforcement actually leads to a decrease in total revenue. We are beginning to see this in 2026. As men move into the gig economy or become digital nomads, the traditional wage withholding mechanisms of Title 4D are becoming less effective. When a man works as an independent contractor or for a company based outside of U.S. jurisdiction, the state's ability to automate his debt collection is severely hampered. This has created a game of cat and mouse between the administrative agencies and a mobile, tech-savvy male workforce. The historical trend shows that when the cost of compliance exceeds the perceived benefit of participation in the system, people will find ways to exit the system entirely. This brings us to the grandfather effect. In 2026, we are seeing grandfathers who were divorced in the 1990s becoming the primary financial and emotional support for their sons who are now facing their own divorces. These older men are providing the playbook for survival. They are funding the legal battles that they themselves couldn't afford 30 years ago. They are acting as witnesses in custody hearings, providing the stable housing that their sons need to secure 50-50 time, and offering a historical perspective that prevents the younger generation from falling into the same psychological traps. This multi-generational alliance of men is a new factor in the family court ecosystem, and it is beginning to rattle the visitor status quo. But as men adapt, so does the opposition. We are seeing the rise of no-fault 2.0, where the legal system attempts to redefine abuse and coercive control in such broad terms that almost any marital disagreement could be used as a basis for a restraining order. This is the new frontier of the silver bullet strategy. In an era where physical violence is increasingly rare and heavily punished, the battleground has shifted to the control of the narrative. Every text message, every argument over a credit card bill, and every disagreement about parenting styles is being cataloged as potential evidence of emotional abuse. The 20th century taught us that the law follows the money. The 21st century is teaching us that the law follows the data. We have explored the destruction of the male identity, the rise of the divorce industrial complex, and the technological surveillance of the father. But what is the final destination? Is there a version of the American family where the state is not a third party in the bedroom? In the next part, we are going to look at the reformer's blueprint. We will analyze the specific line-by-line changes to federal law that would be required to dismantle the Title 4D incentives and restore the presumption of parental equality. We are moving from the history of what went wrong to the architectural plan for what could go right. The future of the American man depends on whether we can decouple the love of a child from the revenue of the state. If you want to see what a fair system actually looks like, you cannot miss the next chapter. To understand how the current architecture of the family court might be dismantled, we have to look at the specific, high-stakes legislative pivot points that have been identified by legal reformers over the last 20 years. The reformers' blueprint is not a set of radical new ideas. Rather, it is a surgical plan to reverse the 20th century trends that turned a civil contract into a state-managed revenue stream. Imagine a man named Christopher in the year 2026. Christopher is watching his state legislature debate a bill that would fundamentally decouple child support from state funding. This is the first and most critical step in the blueprint, the repeal or radical amendment of the Title IV incentive structure. As we have explored, the federal government currently provides a commission to states for every dollar collected. A fair system, according to historical trends in legal reform theory, would replace this with a flat-fee administrative reimbursement. This change would immediately remove the financial incentive for states to maximize child support orders or to favor one parent as a primary custodial cash generator. For a man like Christopher, this means the potential outcomes of his custody hearing would no longer be influenced by a state's budgetary needs. Step by step, the elimination of the profit motive at the institutional level is the only way to ensure that the best interests of the child standard is actually applied with neutrality. The second pillar of the reformers' blueprint is the implementation of a true equal shared parenting presumption. This is the Kentucky model, which in 2018 became a landmark case study for the rest of the nation. Before this law, fathers in Kentucky were struggling with the same visitor status common in the 1990s. After the law passed, which established a rebuttable presumption that 50-50 custody is the starting point for all fit parents, the state saw a significant drop in domestic litigation. Why? Because when both parties know they will start at 50-50th, there is no prize to fight for. The incentive to use the silver bullet strategy, filing false allegations to gain a tactical advantage, is severely diminished because the court requires clear and convincing evidence to move away from the 50-50 baseline. Step by step, a fair system would also address the imputed income trap. Reformers argue that child support should be based on actual, realized earnings, not a judge's theoretical guess of what a man could earn if he worked 80 hours a week. In this blueprint, if Christopher loses his job, his support obligation would automatically adjust to his current financial reality, preventing the accumulation of the unpayable arrears that have haunted men for decades. This would be handled through a real-time adjustment system, similar to how income tax is withheld, ensuring that the father is never pushed into the shadow economy just to survive. Furthermore, the blueprint calls for the total reform of spousal support, or alimony. The historical trend in reform-minded states like Florida and Massachusetts has been the abolition of permanent alimony. In a modern economy, spousal support is being redefined as rehabilitative and durational. A man would no longer be tasked with maintaining an ex-spouse's lifestyle indefinitely. Instead, support would be capped at a specific percentage of the marriage's length. For example, 0.5 years of support for every year of marriage, with a hard cutoff. This recognizes that the goal of divorce is for both individuals to become self-sufficient entities, not for one to remain a permanent financial dependent of the other. Imagine if the legal system treated time with the same administrative rigor as it treats money. In the current system, if a man misses a payment, the state's enforcement machinery kicks in automatically. But if a mother denies a father his court-ordered visitation time, the man often has to spend thousands of dollars on a contempt of court motion, which may take months to hear and result in nothing more than a verbal warning for the mother. The reformers' blueprint proposes an administrative enforcement of parenting time. If a parent denies time without a valid emergency, the state would apply the same penalties it uses for child support: license suspensions, fines, and eventually, a mandatory transfer of custody. This equivalency of enforcement is essential to restoring the American man's faith in the rule of law. Let us look at a case study regarding legal parity. One of the biggest hurdles for men in the 20th century was the resource gap. In many divorces, the court allows the lower-earning spouse to use the higher-earning spouse's income to pay for their own legal fees. This means a man is often literally paying for the lawyer who is trying to strip him of his rights. A fair system would move to a loser pays model or a flat-fee mediation requirement. By mandating mediation before any litigation can occur, the state could divert 80% of cases away from the adversarial courtroom and into a collaborative environment. This would protect the marital assets from being drained by the legal industry, ensuring that the money stays where it belongs, with the children. This blueprint also includes the right to a jury trial for family law cases. Currently, in most states, a single judge has total power over a man's life. Reformers argue that because a divorce involves the fundamental constitutional rights of parenting and property, men should have the right to present their case to a jury of their peers. This would act as a massive check on judicial bias and the good old boy networks that often exist between local judges and prominent divorce attorneys. For Christopher, the knowledge that 12 ordinary citizens would decide his fate, rather than one individual who may have a personal prejudice against fathers, would fundamentally change the psychological landscape of the trial. However, we must also address the digital due process. As we enter the mid-2020s, the blueprint suggests that all child support and custody records be handled through a transparent, blockchain-verified system. This would prevent the sewer service and clerical errors that we discussed in the era of automated enforcement. A man would have an immutable record of every payment made and every hour spent with his children, making it impossible for an agency to lose data or for an ex-spouse to claim non-payment when the record proves otherwise. This is the transition from trust the system to verify the data. The reformer's blueprint is a vision of a world where divorce is a tragic end to a relationship, but not a state-sponsored execution of a man's future. It is a world where fatherhood is recognized as a fundamental right that cannot be bought, sold, or bartered by a legislature seeking federal subsidies. We have seen the history of how the system was built to extract. Now we are seeing the plans for how it could be rebuilt to protect. But as we look toward this potential future, we must ask, who is going to lead this charge? Is it the men themselves? Or is it the children who are now growing up and demanding a different world for their own families? In the final part of this masterclass, we are going to look at the cultural synthesis. We will examine the final legacy of the 20th century and the emergence of the integrated father in 2026. We will look at how men are finally moving past the victim and villain tropes to create a new definition of masculinity that is both resilient and legally protected. This is the conclusion of our deep dive, the final reckoning of a century of struggle and the first glimpse of a new horizon. The 100-year war is ending. What comes next will define the next millennium of the American family. The final reckoning of the 20th century divorce machine is not found in a law book or a government ledger, but in the cultural synthesis occurring in the minds of American men today, in the year 2026. We are witnessing the birth of the integrated father. To understand this evolution, imagine a man named Julian. Julian is 35, married, and a father of 2. Unlike his grandfather in 1950, Julian does not view himself as the untouchable head and master. Unlike his father in 1990, he does not view himself as a secondary visitor or an ATM for the state. Julian represents a historical trend where men have internalized the brutal lessons of the last century and are using them to build a new, more resilient version of domestic life. He is a man who is emotionally present, legally informed, and socially networked. Step by step, the first major component of this cultural synthesis is the rejection of the disposable father narrative. Throughout the late 1900s, the legal system and popular media often portrayed fathers as optional. In 2026, the data has finally caught up with the reality. Long-term case studies now show that the absence of a father is one of the single greatest predictors of negative potential outcomes for children, from incarceration rates to mental health struggles. This data has empowered men like Julian to stop asking for permission to be parents. They are asserting their presence as a biological and social necessity. This shift is moving the conversation from what a man owes to what a child deserves. The presence of both parents on equal footing. The second component is the financial decoupling of masculinity. For most of the 20th century, a man's worth was tied directly to his ability to provide, which the divorce courts used as a tether to keep him tethered to the state's collection machinery. In 2026, we see a historical trend where men are diversifying their identity. They are no longer willing to be defined solely by a paycheck that can be garnished at the whim of an administrative agency. This has led to a rise in shared breadwinner households where the financial risk of divorce is naturally balanced. By ensuring that both partners are equally capable of self-sufficiency, men are reducing the potential outcomes of a lifestyle-based alimony award, which was the primary weapon of 20th century family law. Let us look at a case study regarding the social architecture of 2026. Men are no longer isolating themselves during domestic crises. In the 1980s, a man facing divorce often did so in silence and shame. Today, the fraternal safety net has moved from church basements to global digital platforms. Men are sharing legal strategies, providing temporary housing for brothers in transition, and acting as a collective lobby. This historical trend has turned the individual man into part of a demographic bloc. When a judge in a small town makes an egregious ruling against a fit father today, it doesn't stay in that courtroom. It is analyzed, deconstructed, and publicized by a community of millions. This transparency is the ultimate disinfectant for the star chamber dynamics of the previous century. Imagine if the 20th century was a long, painful education in the law of unintended consequences. The no-fault revolution was intended to reduce conflict, but created a billion-dollar litigation industry. Title 4D was intended to help children, but created a state-sponsored incentive to keep fathers away from their homes. In 2026, the cultural synthesis is about correcting these errors through private governance. We see more couples entering into parenting contracts before a child is even born. These are not just legal documents. They are moral maps that define how the parents will interact regardless of the status of their romantic relationship. Men are taking the initiative to define the terms of their fatherhood outside of the courtroom, creating a parallel legal system based on mutual respect and data-driven child development. The legacy of the 20th century is also visible in the new guard of the legal profession. A generation of young lawyers, many of whom are the children of the divorce boom themselves, are entering the family law bar with a mission to end the adversarial model. They are pushing for collaborative divorce, where the goal is a no-court resolution. Step by step, they are dismantling the win-loss mentality that fueled the silver bullet strategies of the 1990s. For a man in 2026, the potential outcomes of a separation are increasingly being managed by professionals who view a win as a stable, two-home family rather than a total victory for one side and total ruin for the other. Furthermore, we must address the global context. The American experience of divorce is now being compared to international case studies in Scandinavia and parts of Europe, where 50-50 shared parenting has been the standard for decades. This cross-pollination of ideas is forcing U.S. legislators to admit that the American way of divorce was an anomaly of the late 20th century, not a universal truth. Men are pointing to the lower rates of social conflict and higher rates of child well-being in these equal parenting societies as the blueprint for the 21st century U.S. The historical trend is a move toward global standards of parental equality, leaving the visitor dad model in the dustbin of history. This deep dive has taken us from the adultery photos of the 1920s to the administrative algorithms of the 2000s and finally to the integrated father of today. We have seen how the system tried to turn the American man into a data point, and how the American man fought back to remain a parent. The 100-year war is ending because the math no longer works and the culture no longer accepts the old tropes. The broken home is being replaced by the expanded family, where the state's role is minimized and the father's role is maximized. As we conclude this masterclass, we must recognize that the future is not something that happens to us. It is something we build with the knowledge of the past. The men of the 20th century paid a heavy price in assets, time, and sanity to show us where the traps are located. In 2026, the modern man stands on their shoulders. He is the guardian of his own legacy, the protector of his children's right to both parents, and the architect of a new social contract that values the bond of fatherhood above the revenue of the state. The 20th century was the era of the courtroom. The 21st century is the era of the home. The battle for the American father has been won not with a final gavel, but with a quiet, persistent refusal to be erased. We have deconstructed the machine. Now it is time to build something that lasts. The history is written, but the future of your family is in your hands. This concludes our 10-part deep dive into the history of divorce for men. The evolution of the family court is a mirror of the evolution of the American man himself, from a rigid legal role to a resilient, integrated human being. The question remains: as the laws continue to shift, will you be the man who is prepared for the new horizon, or will you be caught in the echoes of the last century? The data is clear, the history is laid bare, and the path forward is illuminated by the hard-won victories of those who came before. Now it is up to the next generation to ensure that the 100-year war never happens again. For every father, for every son, and for the future of the family unit, the era of equality has finally arrived.